Hello and welcome to our video series offering advice and key information for Indigenous businesses during the coronavirus pandemic. I'm Terri Janke from Terri Janke & Company, lawyers and consultants. We are working with Indigenous Business Australia and 33 Creative to support Indigenous businesses during these unprecedented times. This video looks at the impacts of the coronavirus on our obligations and rights in business contracts. Here are some of the key points to consider in relation to managing contracts in the time of the coronavirus. In the current climate of uncertainty, we can expect to see delays in timeframes for the delivery of key milestones, arrangements for payments, and non-performance of contract obligations. Indigenous businesses should look to their contracts to find out what they need to do to discharge their obligations and receive payment, in what circumstances the contract may be terminated, what rights they have to be relieved of their obligations due to the impacts of the coronavirus. This may include a claim under the contract for a variation, a change in law, an extension of time, a relief event, or a force majeure event. What rights they have to recover payment if the client fails to pay the Indigenous business. This may include negotiation, mediation, arbitration, or litigation. It is important you clearly understand what you and your suppliers are required to do by when in order to be paid. This clear understanding will form the basis of your contract negotiations with your clients and suppliers. In times of crisis, cash and cash flow is king. The timing for performance and payment by your client and to your suppliers will make or break your business. Your contract may be terminated for breach of contract, for a delay or failure to provide the goods, services or works within the required time frame due to the impacts of the coronavirus. It is important to clearly understand in what circumstances the client is able to terminate your contract and how and in what time period you may be able to remedy the situation. If you have breached your contract, you may be able to negotiate and agree a way to fix the situation and avoid termination of the contract. Some contracts also allow parties to terminate for convenience. This allows termination of the contract for any reason. Usually these clauses entitle you to a sufficient notice period, payment up to the date of termination and break costs. So check your contract and speak to your client about this option. Depending on the terms of your contract, it may provide relief from your obligations due to the downturn of business in the coronavirus pandemic. This may include a claim under the contract for a variation, a change in law, an extension of time, a relief event, or a force majeure event. Depending on the terms of your contract, you may be able to claim a variation under the contract if the impact of the coronavirus requires you to change the scope, nature, sequence, or timing of the goods or services or work. If you are entitled to a variation, this may allow for an extension of time and additional costs incurred by you as a result of the coronavirus. Depending on the terms of your contract, you may be able to claim a change in law. A change in law occurs if there is a change in law which impacts the performance of your obligations under the contract. This may include a declaration by the World Health Organization or government restrictions on individuals and businesses such as lockdowns. If you are entitled to a change in law, there may be an adjustment of the scope, timing, and costs for the provision of the goods, services, or work. Importantly, this may allow for an extension of time and additional costs incurred by you as a result of dealing with the coronavirus. Depending on the terms of your contract, you may be able to claim an extension of time and delay costs, or seek relief from meeting the key performance indicators for the period you have been impacted by the coronavirus. Force majeure is a contract provision that relieves the people in the contract from performing their obligations when certain circumstances beyond their control arise, making performance of their obligations impracticable or impossible. Knowing which circumstances are covered by a force majeure clause is essential. This may include natural disasters like hurricanes, floods, earthquakes, weather disturbances, and the coronavirus, which are sometimes referred to as acts of God. If a force majeure event includes an epidemic or a pandemic, it is likely that you will be able to claim a force majeure event has occurred and be relieved from performance of your obligations under the contract until the coronavirus has subsided. But that will require careful consideration. Ideally, people in business together should be discussing their ability to continue to work towards achieving the project outcomes during the coronavirus crisis. Good communication, project and contract management during these times means getting on the front foot. For this reason, informal negotiation with your client is the most efficient means of resolving any disputes which arise due to the coronavirus. However, if your negotiations and contract claims are rejected, alternative dispute resolution processes such as mediation may be appropriate. Mediation can enable facilitated discussion between the parties to generate solutions. If a client fails to pay you in accordance with the contract, you may be able to escalate the issue and recover payment by legislative claims, arbitration, or court litigation. Businesses that are subcontracting will be impacted by the upstream issues of the head contractor. This is a common thing in the construction industry. For example, if the head contractor cannot complete milestones for payment or cannot purchase materials, the whole supply chain is impacted. The subcontractor will have no direct contractual relationship with the client, and delays in payment issues may need to be negotiated with the head contractor rather than the client. If you are in this position, you should be in close communication with the head contractor, but also refer to contractors' debts legislation, or if in the building and construction industry, the Security of Payment Act in each state and territory for resolution. This legislation overrides the contract terms and provides for a fast, simplified and cost-effective process for making claims against clients for payments under the contract. The legislation also provides for head contractors to bypass contractors and pay subcontractors directly if an amount is legally required to be paid by the contractor to the subcontractor. To find out more, go to fairtrading.nsw.gov.au and search Security of Payment. You should check your insurance to see whether you are entitled to any insurance proceeds for epidemics or pandemics. For those working in construction, the terms of your performance bond will be important to look at. In construction, a performance bond is usually issued by one party to the other party as security for failure to meet their contractual obligations. If the party providing the performance bond breaches their obligations, the other party may make a call on the performance bond, demanding coverage of their losses. While a party is exposed to a breach that will impact their work performance, they should also mitigate their risk. Mitigation of the risk of a business will depend on the industry, size, geography, and other factors. All businesses should complete a risk management assessment on performance of contracts and consider ways that risk may be mitigated and reduced. Go to www.business.gov.au to find out more. And to watch more of these videos and find out more and keep up to date on the latest information, go to iba.gov.au. We hope you're finding this information useful, and remember, we're all in this together. There will be an end to this, so keep going strong.